Actually, I would like to start first asking you about this recognition of reputed or well-known marks in your office. What you mentioned yesterday for the Jollibee mark, and yeah, how does system work? What implies for those trademarks declared as reputed?
Okay. I would like to call on our supervisors to recite, especially those who declared Jollibee marks as well known. Attorney Irma and Tess were the ones who recommended the declaration of the two Jollibee marks as well known.
I'm just a good soldier, so I can follow the instruction.
Me
So,
as well.
I think it was, I'm not sure if it's what mentioned yesterday, but we recently came up with the regulations on well-known marks. So it was I think, part of the thesis of our director, and it came to fruition this year. We have several criteria to check if the mark is really well known. And we actually considered the WIPO declaration on this regard, and also we added additional. But we consider in terms of the reach, the commercial reach, in terms of if there's prior existing conflicting trademarks, if they have pending cases, so they're able to resolve cases regarding their well-knownness. And then the rest of the answer will be given by Attorney Tess.
Thank you.
Okay. So I was the examiner of the second mark, which is declared well known. So we considered a lot of documents, and we made sure it met the criteria. So we have how many? 12. Okay, 12. Like um, we considered the duration, extent, and geographical area of the use of the market share in the Philippines, the degree of inherent or acquired distinction of the mark, the quality, etc., etc. And then this for this particular Jollibee trademark, personally, I was a bit surprised that it was first declared as well known in Indonesia. So it was a Supreme Court decision, three decisions of their Supreme Court, which declared our Jollibee mark as well known. So what more can
Yeah.
for the Philippines, right? So with all the documents that they gave, it really deserved a well-known mark recognition. Thank you.
Thank you. Thank you. Yeah. In our case, we don't have it in the office, that certificates or recognition for the well-known or reputed marks. So we based on our case law. So one of the evidences that can be submitted as a proof of reputation are recognitions through chambers of commerce, other national judgments, and we give a lot of weight to that kind of evidence. So I think for brands like this one, once receiving one certificate from a trademark office, uh, for us will be a very good evidence and offers a better and broader protection for the trademark. Because one of the reasons behind the Article 8.5 is not only because the trademarks are an indicator of origin, but also in this case of reputed or well-known, they condense the image of the mark. No, so they assure a quality. They convey that message to the consumers, and there is a risk that other parties take advantage, detriment in the use of that trademarks. So, well, this is our regulation. I included some trademarks here, but what I really wanted to share with you are the requirements that we ask in the office for applying the Article 8.5. Okay, so we need that the earlier trademark is registered and the one which is reputed. The, the opponent has to prove that trademark enjoys reputation in the relevant territory and for the relevant goods and services. That means that, for example, the non-registered trademark, the non-registered well-known mark are not an eligible basis for this ground. The signs have to be similar. So we here normally apply the same criteria for the likelihood of confusion examination that we've seen before between the similarity of the signs. It is necessary to establish, once the signs have been found similar, if given all the relevant factors, a link or association between the signs will be established. And this is, allow me to say, the beauty of this article, because we have more margin to establish that link, and I will explain it later. Moreover, the use of that trademark applied for will be like they have to show that it is likely to cause detriment to or take unfair advantage of the distinctive character or repute of the LM mark. And finally, the use of that sign applied for should be without due cause. Um, so the applicant has to, we don't ask the applicant to provide already an explanation during the observations of the due cause of the use, but in case there is, then we require it to, because again, we only examine what the parties submit before the office, not based on our previous knowledge. Because sometimes there are very famous cases of McDonald's, Big Mac, I mean, that we, of course, we know they are reputed, but if the evidence that they submit is not good, we cannot go far beyond, okay? Yeah. Okay. Sorry, I forgot to mention that all those requirements are cumulative, and then we decide on the conclusion whether the opposition based on that well-known or reputed mark is upheld. So what the court told us is that all the relevant facts must be considered in assessing the reputation, in particular, the market share, the intensity, the geographical extent and the duration of its use, and the size of investment made by the undertaking. So there are various issues to address when dealing with the reputation. What do we understand by reputation? Where does the LMR have to be reputed, and how to prove it and assess that reputation? Well, I will put it all. Yeah, sorry. So the market share, the intensity, the duration, the geographical extent, and the investment is something that the opponent has to prove, and we will take it into consideration to ensure that there is a degree of knowledge from the relevant public of that trademark. For us, the territory is very important since we are a regional system. So again, we have to consider whether only the reputation in one member state is sufficient or not, that we have cases that it is, but sometimes it's difficult to assess whether it is a very well-known mark in a very small region. It is sufficient to keep that protection, broader protection in the whole European Union. And maybe within your country, you have the same or similar situations. Then their reputation has to be acquired before the date of the application of the contested mark or priority in case there is. And it has to be for the reputation has to be linked for the relevant goods and services. I have several cases where I know that the trademark is reputed, but it was against, they were showing or trying to submit the evidence for reputation of some goods that were not relevant for the case. No? So I put it one list of the evidence of reputation. As you see, I already mentioned the previous national court or EUIPO decisions are one of the strongest, but also the opponent can submit market surveys, company profiles, the annual reports, the investments in marketing, the rankings also how the brand is positioned with the competitors in the market. As well, Monica already mentioned the surveys. They have to be objective, they not leading questions, etc. So we normally enter into the details of the questionnaires as well to ensure that it has not been somehow leaded. Okay. So when we consider the similarity of the signs, one of the cumulative requirements, the method of assessment is the same as in the case of Article 81B, but the standard of similarity is not the same. And I will have some examples later on, because there are some cases where maybe that similarity between the signs was not sufficient to lead a likelihood of confusion on the 81B, but it might be sufficient because of the reputation of the mark. We will see with another case from Starbucks. But if the signs are completely dissimilar, there is no similarity at all, then there cannot be infringement. Therefore, our opposition will end up here. Okay. So for the link between the signs, we take into account several factors. Sorry, the degree of attention, the similarity of the signs, as I said, and we take into account as well the overall of the public. And here, the spillover beyond the relevant public for the goods and services of the earlier reputed mark. So that's why I said that requires as well an analysis of the relevant public. It's not the same, as I mentioned, the pharmaceutical sector or the automotive, that they are used to that kind of trademark. So we take into account as well the public under analysis, as well as the proximity of the market sectors. And we do the classic test, we mentioned like that, of assessing the similarity of goods and services, as I showed you before, but it will not necessarily lead the same conclusion. Okay. And then we assess as well if whether the trademark is inherently distinctive or not. So it all goes case by case. But I wanted to put emphasis on the link, because here it goes beyond of the protection between the similarity of goods and services normally, because if we can establish that there is a link between the both trademarks, then the reputation and the success under Article 8.5 of the opposition will be granted. So we take into account the similarity of the signs, the likelihood of confusion, as I said, so all are cumulative. The proximity of the goods and services. In the case of the proximity of the goods and services, we take into account as well the market reality. So we have a case for sunglasses with flip-flops. Do you think there is any connection between those goods? Yes, right? Because the beach, the summer season, so probably you will encounter in the same shops fashion designers as well as accessories. So that will be considered as a link between, I was mentioned similar, but no, there is a link between them. But what about these protective glasses versus the sunglasses? Do you think there is a link? Both are for protection of view, okay? But in this case, was considered in the Ipanema that especially for the protective goggles, there is no link. Okay, normally for the protective items that are registered in class 9, they have a specific manufacturers, and normally not sold on the same stores, different trades, and that's why the link was not found in that case. Of it was for the flip-flops. Yes.
Yes, Cristina, everything seems very psychological. So it seems like everything is on the mind of the consumer rather than objective. So I was thinking who and how he decides, the examiner, if there is a link on the mind of the consumer. How, I understand, I have to convince you. I have to convince, as a lawyer, I have to convince the examiner, the UIPO, that there is a link, right? Otherwise, the examiner has to defend this or has to uh, make up things. You know what I mean?
Yes, yes, I know. Yes, that's why I said that is one of my favorites, relative grounds, because for the examiner also gives the freedom of deciding. Not is not so strict as with the similarity tool. For example, that we know that okay, if they coincide in this criteria, then they are similar or dissimilar. Here, the parties can convince the examiner through the evidence.
So it's all about how the lawyers explain, how the lawyers argue, and yeah.
Yes,
Yeah.
I think so. Well, if the doing the analysis of under 8.1b, the goods are similar, then it is not necessary. But in those border cases where, for example, there is a brand extension that, according to our normal comparison of goods and services, they will be considered as dissimilar. But if the earlier mark is reputed, then we can find a link there.
Thank you.
Yes. I did a spoiler again. Well, in the case of energy drinks and alcoholic drinks, also was considered that there was there is this general court decision. There is a link between them because normally are consumed together. They are complementary. If we will go to a normal likelihood of confusion examination, we will say that they are dissimilar because one contains alcohol, the other one not. Different producer, different distribution channels probably. But since there is a strong connection, especially in the youngsters, no, to then it was proven the link between these two sectors. And apart from the proximity, as I said, the market reality. So here we have, for example, the brand extension. Many companies that do clothing also extend to, for example, home uh, sheets and all this. Also the merchandising as well. It is very common that when a trademark is very reputed, it extends to all different kind of products. And also the evidence on the merchandising is very useful for the examiner to decide, because it means that it has extended. Not the consumer will expect that trademark not only in, for example, bags, but also in toys because of the franchising agreements. The sponsorship as well. Many sport clubs also, or sportive clothing companies sponsor, team clubs and all this for playing sports. So it's very common as well. And then the relevant public, as we said, and the inherent distinctiveness of the mark. As well, another factor is the degree of reputation or strength of the alien mark. It's not the same that we compare, I don't know, Coca-Cola, or we will see another case of Puma. They're very worldwide well-known marks. They have a broader protection than other trademarks that have a very limited sector on the market. So depending as well in the degree of reputation, we'll have more chances to success. So here is the case of Puma. Here, let me check my notes, because the opposition was based on the Puma well-known mark, and it was against very specific and technical goods. Sorry. So even though Puma has a very high degree of reputation recognized, it was not sufficient for establishing the link with this, in class 7 machine tools, so motors. So even if the public, the specialist public of those sectors was aware of the brand Puma, it was not found enough to find a link. Because even if the specialist will encounter that trademark in the tools, they will not associate and think that the same company is behind. Okay, this one was a bit controversial. Another of the aspects that we can consider is the family of marks. And here we have the case of McDonald's. So looking at the family of the marks in this coffee case, the opponent was able to show that they had a range of marks like McCaffin, McRib, McFlurry, McNuggets, etc., all derived from the McDonald's trademark. And it fulfilled the conditions to form a family of trademarks because they were sufficient in number and reproduced in full the same root of MC. So then it was a higher protection, let's say, because they were able to show that they existed in the market the family of marks. So the overall assessment of all the factors then is essential to consider the reputation of the mark. We have to bear in mind, of course, that the trademark has multiple functions, not only the indication of origin, as I said, but also that it is used as a marketing tool. So it is a sign of quality and the image that is associated with a brand, and its reputations are assets that have been created in the course of time as a result of huge investments by the trademark owners in terms of financial aspects, time, and resources. And that's why we provide a broader protection for that type of trademarks. Do you have any questions so far from the reputed? No? Okay, we can go to some examples. Here, what do you think? Is it an existing case? Do they have a similar appearance? Good, sorry. Ah, sorry. The goods are for, yeah, coffee. Well, um, in this case, the boards of appeal find that they were similar to a limited extent, orally similar because of the coffee, and conceptually similar as well. But the additional elements invoke other concepts. So in the end, the Board of Appeal found them dissimilar, as they mere coincide in the non-distinctive term coffee for coffee. But then it went to the General Court, and there is where it was decided by the General Court that they have the same general appearance. And based on that, even though they only coincide on the non-distinctive term coffee, it reminds to the consumer of the same impression. Yeah,
Okay,
please.
okay, Christine, let me understand. So, under likelihood confusion,
Mhm.
we forget reputation. This case will be clearly not confusion. Okay.
Yes.
So the Board of Appeal in this case said no.
No. Yeah.
So it will still fail. But the fact that Starbucks has this strong reputation made that the similarities that could be found on the mind of the consumer can lead to a reputation case.
Exactly.
Okay, and now my question is, what are the limits for two signs to be dissimilar? Because I understand practice in the past was very broad and now is very strict. Because for me, here there is no confusion at all. So if it's dissimilar, I understand that the marks cannot, cannot even be compared. And my question is, what are the limits on the similarities? So what makes a mark dissimilar to the other, and uh, how this applies to reputation? Because I'm asking you because this is one of the main priorities for IPOFIL, to understand the reputation cases and actually those type of cases are quite useful for them and also for me to understand a bit also. Thank you.
Yes. Well, from UIPO practice, strictly speaking, when I receive a case, if they coincide in some letters, then I cannot say that they are not similar because they coincide visually, orally in some of the letters. So probably those two, if I have an 81B normal likelihood of confusion, I cannot say directly they are dissimilar. So I will have to enter into the comparison and say, okay, they coincide in coffee. Coffee is non-distinctive for the, and then I will say no likelihood of confusion. But I cannot say completely dissimilar. So it is when really the signs do not match in anything. Okay. And the particularity of this case is that finally the General Court upheld the opposition based on this yeah, they call it same general appearance. They also included that the circular devices also has something in the middle and border. They coincide as well in the position of the starts and the nodes that are included in the circles. So, and especially as Gonzalo mentioned, they take into account the extensive reputation of the trademark of Starbucks, that is included in amongst one of the top 100 brands in the world. Okay. Yes, please.
Yeah, thank you for the explanation, Christina. But just for academic discussion, do you think the decision would be the same if the contested mark appears or claims the color red?
Yes, that's interesting. Yeah, because then is another additional difference. Yes, and maybe the same overall impression of the signs might change. But I guess also the situation, how they are placed on the signs, might lead you still to the same overall appearance. But yeah, the colors is something to consider as well. Yes, and I have some cases even that it's difficult when the reputed mark has contains a generic term. Okay, we have well, I'm not going to give details because I don't want to give the mark, but for sanitary products and has somehow healthy, sunny something, and now they are opposing to every trademark that contains that sunny or healthy thing. And where is the boundary there? No, so we are giving us, and in the end, a monopoly of a term that that is descriptive of the goods. So it is impeding of the competitors to use that term. But that's another discussion as well.
In the yeah, thank you very much. In the earlier example also of Puma,
Mm.
so Puma used for machines or yeah under class 7, but because Puma is an as applied in that particular case is an arbitrary mark in the spectrum of distinctiveness, but perhaps that's what makes trademark examination interesting, because if we change the facts, if it's not Puma, but instead it is a fanciful mark, let's say Lacoste or maybe Reebok, the decision may change entirely, or maybe it would have been more complex to decide if it's not Puma. Because Puma, since it's an arbitrary mark, then it may be freely available, or uh, the its availability to the other um, players in the industry, maybe higher compared to if the mark is a fanciful mark, let's say, yeah, Lacoste or Reebok. So maybe the level of reputation of fanciful marks would be different compared to Puma. That's why there, I think the decision was in favor of the Puma for Class 7. There's no link,
Hmm.
right? But maybe if it's like Lacoste or Reebok, maybe would have gone in favor of the, the original Lacoste and Reebok.
Yes, yes. And one of the factors that I mentioned is the inherent distinctiveness of the mark. So the more distinctive is the repeated mark, more weight has. Yeah. So it can counterbalance the outcome. Yes. Yes. We can move to other examples. Here, let me give you the details of the case. In this case, the LM mark is the Chianti Classico and owns a collective Italian trademark. So in this case, also we have a collective mark involved featuring a black rooster or gallo nero. Okay, the company the contested mark applied for the figurative mark named Hishu, which also included the depiction of that rooster. In that case, the Chianti Classico opposed to the registration before the EUIPO, claiming that the new trademark infringed its collective trademark rights, especially given the strong reputation of the Black Rooster mark. In the end, yes, yes, yes,
We have a question.
yeah,
Actually,
sure.
my question is related to the previous
The previous
topic
one.
regarding links of the goods and
Ah,
services.
okay.
How do you consider this in your office? For example, there's this mark ABC hotel, a reputable hotel,
Yeah.
for class 43. And then there's another mark, ABC also, which covers linens, class 24.
Hmm.
How will you treat those two? Are they like what you said before? Is it there's a link between the two?
Yeah. First of all, I will go to the evidence that the parties have submitted. Mm, but I must confess that I sometimes perform searches myself, and even now with ChatGPT, also it's very convenient to ask, like, are there normally companies who perform, for example, I will ask that do the services of a hotel in class 45, but also produces their own sheets, no cover sheets. Yeah, so I see the connection there, and then I will see how is the trend on the market. If I see that it's a very rare occasion, then probably, unless there is a strong evidence from the opponent, probably no link can be found. Also from case law, sometimes we base on the precedents from other cases decided. Yeah, so I would do that. Yes,
Thank you.
but sometimes we are surprised even from the case law from the general court where they found links in very, very separate market sectors. Yeah.
There's another interest. So we're sharing experiences now.
Mm.
There's another interesting case, but this happened a long time ago. There's this famous trademark for restaurant, which Gonzalo happened to visit last Monday. I will not tell the name of the restaurant first. So it's a famous restaurant, but there's another company which registered that very same name of the restaurant for shrimp paste. You know um,
Yes.
the baby shrimp, the salty condiment, which we usually eat together with another famous Filipino dish, which happens to be another favorite of Gonzalo, kare kare. So now I'll reveal the mark. It's Barrio Fiesta. It's famous name for a restaurant, but there's a separate entity which registered Barrio Fiesta for the shrimp paste.
Hmm.
So Barrio Fiesta is also known for serving kare kare, the dish that goes with the bagoong, traditionally called bagoong, the shrimp paste. But they coexist. But I don't know if they assigned the one. The, I know. I think they haven't assigned the bagoong mark to the owner of the restaurant, but they coexist. But for me, the link is very clear. between the
Yes.
restaurant and the shrimp paste.
Yes, and also because in market, also we have many restaurants that also sell their own food with their brand or even franchise it. So yes, I see the link as well there.
But just and if you allow me, this link, as Cristina was saying, that this is fun for examiners, something like that. You said like reputation is not about similarity; it's about it has this psychological aspect. So it's on the lawyers, on the parties, to show that there is a link. So basically, they have to create good literature to convince. It's about I will even seduce the examiner why there is a link. Convince me. Based on that, apart from the evidence, because the evidence itself, you can like if you allow me, I can tell you a case happened in UIPO. I remember it was the Big Mac case. Big Mac, McDonald's.
Mm.
You remember this?
Okay.
So basically, they were not able to show the reputation of Big Mac, but everyone will think that they have. Of course, they have reputation, but they didn't file the reputation. The in the sense of convincing, they didn't do the homework. Obviously, in the appeal, they manage and they sort this out, but it gives bad image. It gives bad publicity to them. It went on on the newspapers, etc. Because in the trademark law in the European Union, I will say the proof of use is one of the most important aspects of the trademark law. The evidence, proof of use, reputation is different, but it's the same evidence. But it's the same, let's say, type of evidence, polls, etc. So just complementing your
In the EU, in that Big Mac case in the EU, what are the goods involved or services involved? Both hamburgers or both food, different
Yeah, I
service.
think services for fast food restaurants. Yeah, both of them. So
Yeah,
yeah, I think was for
interesting because
Irish company, the contested one. Yeah.
interesting because in the Philippines there's also an actual Supreme Court case involving Donald's Big Mac
Mm.
and a local food chain called Big Mac with a letter K. But of course, McDonald's won that case over LC Big Mac, the local with a K. It reached the Supreme Court.
Yeah. Okay. I don't know. There was some questions on the back or no? Thank you for sharing. Anyway, uh, I already explained. So yeah. Okay. So this one is also, in my view, quite controversial. Do you think that the signs are similar? Hi. Yeah. Okay. In this case, the general court ruled in favor of the opponent of Chianti Classico. They said that there was a conceptual similarity because both signs feature that rooster and conveys the same semantic idea. The collective mark had a reputation was strong enough to block the later registration, and the products covered by both marks were identical. This is also another factor. So if there is identity between the goods and services, it also a strong factor to consider. So since we are running out of time, you will have the presentation, you have the case reference. So yeah, I will skip some of the cases, okay, for the structure. Sorry. Well, just very quick that apart from the link, we also consider the risk of injury, okay? And we take into account the unfair advantage taken of the distinctiveness, so what we call free riding, as well the detriment that it can cause to the distinctiveness of the LMR, that we call it as dilution, and the detriment to the repute of the LMR. Okay, for example, with the counterfeiting, we see it a lot. So many, for example, there is a Spanish brand for bags and accessories, and it was so much sold in illegal markets and copied that in the end the brand even diluted because it lost the luxury characteristics of that condensed the mark. Okay, and then it is sufficient that there is one type of injury for considering the risk of unfair advantage. So if for the opponent, it's sufficient to prove at least one of them, and then we can conclude on the reputation based on Article 8.5. Well, this was one of the case of unfair advantage, also involving. Yeah, another one from McDonald's. Here for the pollution, even this one for water, and the contested one was for polishing preparation and cleaning preparation. So you can imagine as well how the image of the brand can be diluted. And then we jumped into the trademarks fight in bad faith. Okay, one of the interesting things as well from the bad faith is that we don't have the definition in the law, but it has been clarified through case law. I don't know if your experience is the same. Okay, so what we came up after all the case law is that the bad faith means the dishonest intention when applying for a trademark. What does it mean? That the behavior departs from the honest commercial practices. And then we have to determine this using objective facts. We cannot base on, as Gonzalo was saying, of course, there is a psychological component, and if something smells weird, it's because something is behind, right? So, but we have to establish through objective facts. So we have two main facets or cases: the misappropriation of the rights of a third party, so targeting someone's existing rights, or abusing of the trademark system, like, for example, the refiling for avoiding the proof of use. So using the trademark system, but for other purposes, that it is not the real function of trademarks. So one of the mandatory factors for establishing the bad faith is the dishonest intention. Other factors that are non-mandatory but give us a clue of the existence of this dishonest intention is, for example, that the party already know the existence of those earlier rights, that the signs are similar, the past relationship between the parties, the lack of commercial logic. One trademark that suddenly jumps into a very different trademark sector, so it probably is trying to take advantage of that. The request for payment to surrender the mark, this can be as well submitted by the trademark owner, or a pattern already of past experience of abusive filings. So when the intention of the bad faith is evaluated at the time of the filing of the application, okay, when someone applies for the invalidity based on bad faith. And what happens early in the past also, or later facts during the procedure, also helps to understand better the intent. So all the exchanges between the parties, as I said, some ask for surrender, asking for money, for example, it is an evidence that there is a bad faith. And one of the main aspects is that we presume the good faith, as my colleague Monica said before. Then the burden of the proof is on the challenger, on the applicant that request for the bad faith. So I give some illustrative examples. One is the Neymar case that it is quite famous, so I guess you are familiar with it. We have the case from the General Court. So it's a decision from 2019. And there, the General Court invalidated the European Union trademark for the name Neymar because it was failed on bad faith by a third party and in attempt to profit from the footballer established name. So the court found that that applicant Moreira, that it was called the name of the owner of the trademark, invalidated because of bad faith, also had simultaneous filing trademarks for as well for other football players like Iker Casillas, and indicated as well of the awareness of the knowledge of the footballers and their renown, making his claim of because he tried to say that he didn't know that Neymar existed or the football player, but then when it was evidence that it also applied for other trademarks for other very well-known football players, then it was decided that of this dishonest intention from the applicant, from, well, in this case, the owner of the contested mark. Okay. Another famous case for bad faith is this of the Simca case, Simca car. In this case, it was between Peugeot Citroën, the owner of the early mark Simca, that it was several years without using that trademark. But a competitor in the market saw the opportunity and tried to use that trademark and take advantage of the famous past of that brand. It is called here like the residual reputation of the historic mark, and then try to refile it in their own name. So to avoid the use of the authentic owner that was Peugeot. So some of the factors here is that the applicants knew that there was a mark that was in the past from the third party, okay? And then there was a lack of honest commercial logic behind of the filing of that trademark. And also it was taking into consideration the chronology of the events leading up to the filing of the contested trademark. Okay, I will finish, I promise. Just one more example. Okay, the monopoly. In this case, as I mentioned before, was another example of dishonest behavior, because here a monopoly company, Hasbro company, refiled repeatedly within 5 years many trademark applications for avoiding the use, avoiding to prove the use of the mark. Okay, so this just for you to have that example. And one final remark. Yeah, it matters because it prevents the unfair competitions, protects the integrity of the trademark systems, and ensure that trademarks serve their true function, which is identifying the origin. Okay, and well, there is also a convergence practice, the CP13, where you have as well more instructions there, okay, that you can consult. And thank you very much. I don't know if you have any other questions. Thank you.